Today we have Clausen Ely, an attorney with Covington Burling in Washington, D.C., who has been representing PPC for many years. Mr. Ely will be presenting some basic information on antitrust laws as they apply to trade associations. Welcome, Clausen.
Thank you. I'll be discussing two broad topics in this webinar. The first is the basic features and principles of antitrust law, and second is how the antitrust principles apply to trade association activities and some practical guidance for following the antitrust principles in trade association activities. The first slide, which is shown now, lists the two basic federal laws which have been in place for many decades, which set out the standard antitrust rules. The Sherman Act, which is a federal law, prohibits any agreements among competitors that unreasonably restrain trade, and the Federal Trade Commission Act prohibits unfair methods of competition. These broad prohibitions have been defined and made more specific over the years through court decisions and through guidance and regulations that have been issued by the federal agencies that are responsible for antitrust enforcement. The next slide lists some antitrust fundamentals. And the first fundamental that I'd like to discuss briefly is the difference between a competitive action that's per se illegal and one that's subject to the rule of reason. The courts and the antitrust enforcement agencies have made a distinction between these two categories of analysis. Per se analysis is one where the courts and the antitrust enforcement agencies have determined that a number of competitive agreements are so likely to harm competition that they are treated as per se or automatically illegal, and no type or amount of justification can be put forth to avoid liability for these kinds of activities. So it's very important to know which activities are regarded as per se illegal, because there is no justification that's regarded as sufficient to warrant such a activity. And this is an area where an agreement among competitors is not automatically illegal. It could be anti-competitive or it could be pro-competitive, but it depends on an analysis of the actual competitive impact of the action, and it requires a detailed investigation of the facts. And I will get back to these two different methods of analysis in subsequent slides. The enforcement of the federal antitrust laws is first the Department of Justice enforces the Sherman Act, and the Federal Trade Commission enforces the Federal Trade Commission Act. And the Sherman Act also authorizes private parties that bring their own lawsuits against companies that they say have restrained competition. Also, virtually all the states in the United States have their own antitrust laws, which are modeled after the federal laws, and state enforcement officials have authority in those states to bring enforcement actions under the state laws. However, those state laws and the principles that apply under those laws are essentially the same as those for the federal laws. The next slide here lists the types of penalties that are can be applied if competitors are found to have violated the antitrust laws, and the penalties are varied and can be very severe. If competitors are found to have joined together to violate the antitrust laws, they're jointly and severally liable, which means that any one competitor can be responsible for paying damages or fines on behalf of the whole group. There are also severe criminal penalties for violations of the federal antitrust laws. There are civil enforcement measures that the government can take, including fines, injunctions, and very damaging publicity. And under the federal laws, private individuals can bring lawsuits for damages that they claim were caused by anti-competitive behavior, and any damages they recover can be tripled under the law. So the summary of this is that the penalties for violation of antitrust laws are very severe, and it's very important to try to avoid any appearance of having entered an anti-competitive agreement. The next slide lists some of the most important per se antitrust violations. As I mentioned earlier, these are violations that are regarded as being so likely to harm competition that if they are engaged in, they will be illegal, and there's no justification, there's no economic justification that can be put forth for these activities, which means that for members of a trade association, it is very important to avoid any agreements in these areas. The first area is price fixing, and it's important to recognize that the prohibition against price fixing among competitors includes not just the total price of a product, but also any significant element of the price, including discounts, credit terms, delivery charges, warranties, or any other element of the contract price that has an important bearing on the transaction. The second area of competitive agreement, which is per se illegal, is any effort to allocate markets, territories, or customers. The third area that is per se illegal is any group boycott or refusal to deal. This is an agreement among competitors not to sell to a particular customer, or agreements among competitors not to buy from a particular supplier. These kinds of agreements are prohibited, and there's no justification for them. Similarly, restrictions on supply or capacity, or agreements to standardize or limit costs are per se illegal and must be avoided. As I'll cover a little later, it is possible for trade associations to legally disseminate information relating to costs, but not to agree to limit costs. It also should be borne in mind that because of the sensitivity of these four broad topic areas, and because any agreements in these areas are per se illegal, it is good practice for trade association members to avoid any discussion of these kinds of agreements, so that there can be no argument or implication that competitors were conspiring to do any of these activities. The next slide lists a number of trade association activities that are traditionally regarded as legal and appropriate, and that meet the antitrust criteria. And I'd like to briefly go through these topic areas and discuss them one by one. The first topic area is advertising and promotion. It is proper under the antitrust laws for trade associations to promote their generic products or services or other forms of promotion, and it is a common appropriate activity of trade associations. However, any advertising or promotion program by a trade association should not limit the freedom of the individual members of the association to decide how to advertise or promote their own products. The second area of traditional trade association activity that is entirely appropriate under the antitrust laws is government affairs. Under the First Amendment to the U.S. Constitution, industry groups, such as trade associations, as well as other persons, have a right to petition the government and to seek to influence government action. That means that trade associations can comment on proposed legislation, comment on proposed regulations, advocate legislation, and otherwise try to influence government action. And this is an appropriate area. It should be borne in mind, however, that if a trade association plans to submit sensitive commercial information, such as price or cost data, to the government in connection with a comment or effort to influence the government, that data should be collected and reported in a way that would avoid disclosure of individual company data or any sensitive data. The third area of trade association activity, which is traditional and appropriate, are statistical programs. Competitors can appropriately exchange a wide range of commercial data under properly designed statistical reporting programs. And this can include sales volume, price, cost, inventory, and other data of this kind. However, in implementing a statistical program, it is important that trade associations follow certain practices. First, the information needs to be largely historical rather than based on future predictions. Second, no individual company data should be disclosed, and an adequate system needs to be in place to maintain the confidentiality of individual company data. And finally, participation in trade association statistical reports must be voluntary. Another area of traditional trade association activity is joint research. And again, in this area, it is proper for competitors to join together to finance research. This type of activity is judged under the rule of reason. And often it can promote competition for competitors to jointly get together to finance a research project that no individual company could afford or do on its own. However, it's generally inappropriate for competitors who jointly finance a research activity to agree on what they will do with the technical data once it has been generated. That is a subject for individual companies to decide themselves. A further area of traditional trade association activity, which can be proper under the antitrust laws, are standards and certification. Trade associations often issue guidance for product standards or certification for certain kind of product attributes. And these may be published by trade associations. But if they are, there are several general rules that must be followed. First, these types of standards must be voluntary. They cannot be enforced by the trade association or by competitors. They can only be enforced by the government. And any industry standards that are published by a trade association have to be formulated in a fair manner where every affected company has an opportunity to give input and to comment on the standard. Also, standards that are published by trade associations ought to generally be minimum standards that permit companies to achieve a higher level of capability and only set a floor. The final topic that I would like to discuss briefly here is the antitrust principles that apply to membership for trade associations. Trade associations can define the types of companies that they are going to represent, But once they do that, trade association membership must generally be open to all qualifying companies that meet the definition within the bylaws of the association. And no qualifying companies can be arbitrarily excluded from a trade association where they meet the membership criteria. However, the association is free to define the scope of the association's membership in terms of the particular business segment that it covers. Also, members can be expelled for failure to pay dues, failure to follow trade association rules and bylaws, and otherwise for inappropriate activity. But other than instances of that kind, the trade association must be open to companies that qualify for membership. So this is a brief review of the basic antitrust principles that apply to trade association activities, and a brief discussion of the kinds of programs that trade associations traditionally administer and ones that are acceptable under the antitrust laws. So now I'll see if there are any questions.
First, is it permissible to deny trade association statistical reports to members who do not participate in the reports?
Yes, it is, because as long as the membership in a trade association is open, as it should be, to any company in the industry that qualifies for the definition of membership, then non-members are free to join a trade association, and then they can participate in and receive statistical reports. So there's no requirement that trade associations provide their statistical reports to non-members or provide non-members an opportunity to participate in statistical reports. However, trade associations are free to do that if they wish, and some trade associations do permit non-members to participate in selected statistical reports and provide those reports to the non-members.
Okay. And also, is it permissible to exclude non-members from participation in trade association statistical reports?
I'm sorry, I think that was the question we just discussed.
Well, is it, if there's a non-member that wanted to participate, can that be, is that ever allowed, or is that? Yes,
as I mentioned, if a non-member would like to participate in the trade association statistical report, it is permissible for the trade association to let that non-member participate, but they're not required to.
Okay. All right. Well, thank you very much for this presentation. And to our audience, if you do have any questions for Clausen, his email address is cely@cov.com. Thanks again, Clausen.
Thank you.
Okay, bye.